trust are essential to our democracy. So I certainly want to work with you to address these concerns, but just wanted to give you a different perspective.
Thank you. Appreciate it. Our last panel is Kimberly McCullough from the ACLU of Oregon, Beth Wooten from the National Lawyers Guild, and in making her first appearance in this chamber as Commissioner-elect, Joanne Hardesty. Welcome. Thank you for being here.
Mayor Wheeler and council members, thank you for the opportunity to testify today. I do want to let you know that I have fairly extensive comments, which I'm going to try to get through quickly. I have submitted written testimony to the clerk, so she can distribute that to you all. I'm also happy to answer questions. I know a lot of this is complex constitutional law, and I also have Matt DeSantos, our legal director, here in case I need to pitch hit on some of those questions. Before addressing the ordinance, I want to acknowledge that we share concerns about the safety of our communities and the desire to make Portland an inclusive and equitable city. And we don't want to downplay the challenges that we're facing or suggest that we sit idly by when violence occurs in our streets. At the same time, we have deep concerns about this ordinance being presented as a solution to the challenges we face. And because we have such deep concerns, we urge you to change course and not adopt it. We believe it will lead us down a path of rights violations and costly litigation. As to our specific concerns, we have constitutional concerns and concerns as a matter of policy. At the outset, we are hard-pressed to see how this will actually prevent violence from occurring or reduce the use of law enforcement resources and police enforcement. Despite the suggestion that the imposition of these rules will reduce violence, we fail to see how that's actually going to be accomplished and instead have numerous questions. For example, if a person is willing to violate our criminal laws against assault, are they really going to follow these rules about when and where and with how many people they can protest? And if someone comes to our city with the intent of causing harm, and they do follow the rules, is it going to stop them from engaging in violence or problematic behavior at or near the free speech zone or in other parts of our city? It's also hard to understand how the ordinance that gives government additional authority to enforce new rules is somehow going to lead to reduced enforcement. It really is just creating another avenue for enforcement. And the fact that violence has occurred at permitted events with associated time, place, and manner regulations begs the question of whether these new rules will actually stop violence from occurring. We understand that the city's attorney's office believes the ordinance is constitutional, but we respectfully disagree. The problem is we can't just say that reasonable content, neutral time, place, and manner regulations are constitutional and end our analysis there. With these kinds of regulations, the devil is in the details, and those details are incredibly problematic here. There are cases cited in the ordinance. We've also been provided with an additional list of case law that supposedly provides justification for this ordinance, but we have read all of those cases. They are all legally distinguishable with extremely different facts, and none of them deals with an ordinance like what we're looking at here. And the ACLU of Oregon is not alone in pointing to those constitutional concerns. I'm sure you've seen the recent media where there were 3 separate constitutional law professors at reputable institutions that all raised serious concerns with the ordinance. And I think it's important to note that none of us have had sufficient time to analyze this under Article 1, Section 8 and 26 of our state constitution, which provides even a more protection for free speech and assembly. As does some of those constitutional concerns, it suffers from overbreadth and vagueness. It also gives too much power and discretion to city officials, centralizing the power to dictate conditions on the exercise of our free speech rights in a single official. I think as a matter of policy, when we're thinking about this, we need to think not only about our present circumstances, but the future. We should ask ourselves how this power can be used and whether we can trust everyone who will use it to use that discretion appropriately. We also need to think about other locations that may copy this ordinance, and whether or not that copying that ordinance would lead to bad results in a different place. In addition, imposing legal consequences based on a city official's judgment that a group has engaged in a history of violence or has a likelihood of committing violence is extremely problematic. As an initial matter, it's unconstitutional to retaliate against protesters for past protest activity, and there is a heavy presumption against the validity of prior restraint on speech. In addition, in our society, we're entitled to due process and a presumption of innocence, both of which are absent here. Checks on official discretion are extremely important to prevent overreach and dubious findings of violence based on bias against particular groups. That's exactly why this ordinance risks being found to not be content neutral. All of this also raised questions about how judgments about groups of protesters will be made. Is there going to be a list? Is this list going to be public? How do you challenge those findings? How do you get off the list? It reminds me a lot of our gang enforcement lists.
Yep.
On a related note, this also creates a dangerous problem that it will lead to a heckler's veto, which is unconstitutional. Creating a heckler's veto means that one group decides that they're going to go cause problems at somebody else's protest, that they're able to impact that other group's protest rights. And again, that is not a content neutral limitation on protest. In addition, the fact that the ordinance is aimed at specific groups of people is problematic because government should not be in the business of punishing groups of people for the past or present actions of a few people. We have deep concerns about how police will know who is and isn't part of these groups, and we certainly hope we don't have to remind everyone that we do have laws against tracking people's political affiliations.
Yeah.
All of this raises even more concerns about how groups will be regulated as a practical matter. So when there is a protest, who is and isn't in the group? Does every single protest have to go to all the protest zones? I think Commissioner Udaley was getting at this a little bit earlier. So what if you have a completely unrelated protest on the same day? What if it's related to the same subject matter, but it's on the same day? Are you then supposed to go to these free speech zones? It becomes extremely problematic, I think, to try to figure out how that actually plays out. There are also limits on the number of people who can go to a protest, and I am really confused about how that would work. We also have deep concerns about the potential for criminal sanctions. Appreciate that the ordinance that is now before us doesn't have the 6 months in jail, but we still have questions because it says that there are potentially associated criminal penalties, but it doesn't say what they are, which is deeply concerning. And that potential for criminal charges could have a chilling effect on people's exercise of their rights. So this long list of concerns, I think, should be a strong indication that this will lead to costly litigation. There are a lot of things our community needs our time and resources for. Instead of diverting those resources into legal battles, we should be working together to create tangible changes that will truly help protect our communities. I have a long list of things the city could do instead of passing this ordinance, but I'm going to reserve that and say that I do appreciate the opportunity to engage in these conversations with you all. Happy to continue to engage in these conversations and try to find some better solutions. Thank you.
Thank you.
Mayor, Commissioner Fitch, Kimberly, do we have a copy of that?
I sent it to the clerk just
we-
maybe like 10 minutes ago or so. I was proofreading, sorry.
So I'm going to ask if the mayor's staff could track it down, because there's additional stuff you weren't able to get to. And plus,
Yeah.
I have a number of questions I wanted to ask you, but what I'm going to do is wait till all three panelists have concluded their testimony. Then I'll ask the mayor if I can have a few minutes to ask you some questions.
Fantastic, thank you.
Very good.
Good afternoon, Mayor Wheeler and Commissioners. My name is Beth Wooten for the record, but I'm here representing the Portland National Lawyers Guild. I'm going to try to keep it to 3 minutes, but maybe a little over, since I'm representing the organization. So I'm speaking on behalf of the Portland chapter of the National Lawyers Guild, legal workers, lawyers, law students, and jailhouse lawyers engaged in the cause of collective liberation. One of our many projects is protester support for anti-oppression movements. That includes legal observing, the famous green hats, as well as jail support. We understand the desire to stop right-wing violence brought to our city by Patriot Prayer and the Proud Boys. However, we view this ordinance as exactly what Patriot Prayer wants, an opportunity to enlarge the police state that has repeatedly attacked counter-demonstrators at their rallies. This ordinance does three things, and the changes to the criteria, I don't believe change our analysis are concerns. One, it allows the city to arbitrarily place individuals into ill-defined groups. It polices the language of protest to craft what will undoubtedly be overreaching protest restriction. And it enables post hoc justifications for police violence against protesters. Generally, it is true that time, place, manner restrictions are valid exercises of state power per the First Amendment. However, when police are left to enforce these restrictions, counter-demonstrators get hurt. We and so many others have observed this. PPB chooses to send us all they've got. They line up, predominantly facing the counter-demonstrators, and separate the factions. Sometimes with no provocation, the police violently disperse the counter-demonstrators. Most recently on August 4th, counter-demonstrators nearly got killed by police weapons and tactics. We refute many of the factual conclusions made by the ordinance describing these protests. No one but police deploy flashbang grenades, full-strength pepper spray, pepper ball projectiles, and other impact weapons that amount to use of deadly force. The ordinance activates when, quote, when two or more groups have announced plans to demonstrate separately but on the same day, and there is a history of violence between the groups. How will PPB determine who or what a group is? Does someone who likes or comments or is interested in a Facebook event then become a part of the group? These counter-demonstrators aren't organized by traditional notions of groups. People show up and they go to protest because they're passionate about an idea and they want to stand up for it. They don't care who organized the event. They want to challenge the Kavanaugh hearing or stand up to Patriot Prayer. Given the vagueness of the ordinance, if a person wants to exercise their right to demonstrate, would that right be curtailed simply by a Proud Boy on Facebook saying he also wants to show up? This is precisely what Joey Gibson wants. Patriot Prayer wants the city to scramble any and every time he makes a peep on social media. The Portland Police Bureau has shown time after time that they do not focus on individual actors, but instead broadly cast demonstrators as lawbreakers to justify use of force. This ordinance will exacerbate that pattern by creating another layer of restrictions that many demonstrators may not even likely be aware of or understand. How do these written orders get dispersed? Once the written orders are broken, then will PPB have the opportunity to kick our butts or kick the butts of counter-demonstrators, as Chief Outlaw put it in her Lars Larson interview. It's of note that the ordinance cites the Minotti decision to justify its validity. That case came after police actions at the WTO protests in Seattle, reviewing a city ordinance that blocked protest activities where world leaders were gathering. While the Ninth Circuit upheld the ordinance following a crucial constitutional challenge, that was not the whole story of the case. The court found that the individual as applied challenges to the ordinance's enforcement could proceed to trial. That case was ultimately settled. Seattle's then Chief of Police, Norm Stamper, has since recanted the decision to clear protesters with tear gas. As here, this ordinance will just invite further violent police suppression of speech, as well as encourage lengthy, costly litigation. These are important considerations as the ordinance will allow the city to limit the number of protesters at a demonstration. You might think it's incumbent on counter-demonstrators to just not show up, but that's irresponsible and ignorant of the history of fascist movements, which thrive on public normalization of their activities. This testimony is a broad outline that you will be writing and submitting to your offices a legal memorandum detailing our concerns. We urge this council to reject this ordinance and understand that the community has been shocked and injured by the actions of the Portland Police Bureau at these protests. Rather than provide legal cover to state-sanctioned violence, we need to consider proactive alternatives to the threat of right-wing violence. Thank you for your time.
Good afternoon, Mayor, Commissioners. For the record, I am Joanne Hardesty, Commissioner-elect. I want to thank you, Mayor, and City Council members for the opportunity to speak on this ordinance. I am a child of the civil rights movement. As a child of the civil rights movement, I am very aware of the need to counter racist, stereotypical mantras that are meant to incite people to violence. I have been extremely disappointed in watching how Portland Police Bureau has responded to out-of-town hate groups who show up and take over our downtown streets. I believe after the August 1st protest, we were told that both you, Mayor Wheeler, and Chief Outlaw were going to independently investigate why nurses were injured